Are you wondering why your criminal case is taking so long to resolve? Well, I have some ideas about that. I'll share those with you, and that's coming right up. Welcome back to Gustitislaw. If you're new here, I am Steve Gustitis, and this is my channel. I post weekly videos, just like this one, about how to manage encounters that you may have with the police, how to effectively navigate the criminal justice system, and how to defend criminal charges. If you like the video, give it a thumbs up and consider subscribing. It's easy. If you'd like to become a part of the Gustitis Law community, then click on that capital black and white G down in the lower right-hand corner of the video screen. I also enjoy responding to your questions and your comments, so add those down in the comment section below. This video continues our series on your speedy trial rights. In today's video, we will examine some reasons why your criminal case may be taking so long to resolve and whether or not you should be concerned about that delay. Links to other videos in the series can be found down in the description section. Court delays are simply a fact of life for people who get in trouble with the police and who get involved in our court systems. These delays can be caused by the sheer number of criminal cases being filed by prosecutors across our country. Sometimes there are manpower shortages in the court system. Sometimes there are manpower shortages in the prosecutor's offices as well. And frankly, in some parts of the country, there simply may not be enough courts to handle this load. But routine court delay is generally not considered suspicious or damaging to your case. But if you have a question about delay in your case, please talk to your criminal defense lawyer about those questions. Another reason that your criminal case may be taking such a long time to resolve is that your lawyer may be using delay as a defensive strategy and tactic. Delay is a common and oftentimes effective way to increase the probability of a more favorable outcome in your case. And there are 4 reasons how delay can have a positive impact upon the defense of your case. Number 1, the older that your case gets, the less and less the prosecutor may be interested in pursuing that prosecution. In that case, that decrease in prosecutor interest may help give your defense lawyer some better negotiating leverage when trying to negotiate a plea bargain on your behalf. Number 2, the older that your case gets, the greater the chance that the prosecutor's case could become corrupted. Their key witnesses could get new charges against them and be used by your defense lawyer to impeach the witness's credibility. Evidence could be lost, or other things could occur to weaken the prosecutor's case. When the prosecutor's case is weakened, that gives your lawyer a better chance to defend it in court or even to negotiate a more favorable plea bargain. Number 3, the older that your case gets, the more effectively your criminal defense lawyer can argue that the behavior that led to you being charged with this crime in the first place was an isolated incident in time rather than a continuing course of conduct. This isolated incident argument can be used with a prosecutor to try to convince the prosecutor to offer a better plea bargain deal to you. Or sometimes this isolated incident argument can be used in front of a judge or a jury to suggest to them that because this was an isolated incident, that your punishment in this case should be more lenient than what the prosecutor is asking them to do. Number 4, the older that your case gets, the more opportunity that you have to develop what's called mitigating evidence. Mitigating evidence could be anything from a history of clean urinalysis. It could be an improved work history or the furthering of your education. All these facts and circumstances could be used by your lawyer during negotiations with the prosecutor and trying to negotiate a better plea bargain deal for you, or they can even be used in front of a judge or jury to suggest to the judge or jury that your punishment should be more lenient. If you have questions about why your lawyer is building delay into your case, then take some time to talk to them about the strategy and the tactic behind the use of this delay. Deliberate prosecutor delay has the potential to damage and impair your ability to defend yourself. That's why deliberate delay by the prosecutor is considered and weighed heavily against the government in the speedy trial analysis that we discussed in the first video in this series. If you think that the prosecutor is deliberately delaying your case to gain an advantage against you, make sure you talk with your criminal defense lawyer about that problem so you can decide how you can go about managing that problem and protecting your rights to a speedy trial and to a fair and impartial trial as well. Can you think of some other reasons why your criminal case is taking so long to resolve? If you can, why don't you add those down in the comment section, and we can begin a discussion that may help some other people too. The next video in this series will discuss whether or not you should affirmatively request a speedy trial in your case. So stay tuned to Gustitis Law for that next video in our series on your constitutional rights to a speedy trial. Thank you again for watching.